Hello and welcome to the Sidebar, presented by True Crime News, taking you inside the courtrooms of high-profile and notorious cases from across the country. I'm your host, Joshua Ritter. I'm a criminal defense lawyer based in Los Angeles and previously an LA County prosecutor for nearly a decade. You can find me on all social media at Joshua Ritter ESQ or at joshuaritter.com. We are recording this on Wednesday, February 26, 2025. In this week's episode, tense moments in court as a judge rejects a negotiated plea deal for a man charged with the death of a child. Plus, the manhunt for a woman accused of killing her wife, who previously pled guilty to killing her husband. But first, a contentious pre-trial hearing in the case of Boston area woman Karen Reed as attorneys spar over witness communication issues. I am flying solo today, so let's just go ahead and jump right in. First, out of Dedham, Massachusetts, pretrial hearings continue to generate fireworks between prosecutors and Karen Reed's defense team ahead of the woman's second murder trial. With the proceedings scheduled for April 1st, both sides are still quarreling over admissible witness testimony, which could have a dramatic effect on the outcome of the retrial. Specifically, Judge Beverly Cannoni expressed, quote, grave concerns over allegations made surrounding the testimony of ARCA experts Daniel Wolf and Andrew Rentschler. Both men were responsible for recreating the crash scene and told jurors that injuries suffered by victim John O'Keefe were not consistent with being struck by a vehicle. This bolstered the defense's claims of a cover-up in O'Keefe's death while undermining the prosecution's theory that Reed drunkenly hit the man with her car before leaving him to die in the snow. However, prosecutors claimed that the testimony was biased, with the defense offering money to ARCA and offering an outline of what the testimony would contain. At trial, Reed's defense claimed that the experts were hired by a third party and that they never met the men prior to their testimony. However, they later admitted to paying them nearly $24,000 for their testimony after the mistrial, but claimed that the bill came to the lawyers, quote, out of the blue. Judge Cannoni did not make a ruling to allow or deny the testimony, scheduling another hearing for the matter at the start of next month. Not discussed at the pretrial hearing was the federal investigation into O'Keefe's death, which concluded without the filing of any charges. This may diminish some of the strength of Reed's claims of a cover-up, as many of her supporters believe that the federal investigation would help clear the woman. Undoubtedly, there are more pretrial dramatics to unfold ahead of the scheduled April hearings, and we will continue to keep you updated. All right. Well, first of all, I think it's important for us to understand why is all of this an issue? Why is it an issue if there were discussions taking place between the experts, the ARCA experts, the accident reconstruction experts, and the defense ahead of trial? Usually, coordination and communication between attorneys before trial is not only allowed, but it's expected. This is going to be your witness. This is going to be perhaps your star witness. You're expected to speak to that person, coordinate with them, talk about their testimony, ask them potential questions. How would you respond to this? How would you respond to that? To get a lay of the land as to what to expect from their testimony at trial for a witness that you're going to be calling. This was a defense witness. However, in this case, it is an issue because there was an ongoing federal investigation, which we talked about and we'll get to later in a moment. And because of that, the ARCA experts who were originally hired by the feds to investigate this accident and how it all took place, they were then under a federal protective order prohibiting them from having these conversations with the defense, conversations that the defense would usually have. So that's one thing to keep in mind. The other thing is that on top of this, Massachusetts has a very particular obligation in what they call Rule 14, and that has to do with reciprocal discovery. In California, it's a little bit different. In California, where I practice, and more importantly, where Alan Jackson practices, there is such a thing as reciprocal discovery, but it's a little different, and the obligations on the defense are not as onerous. A defense attorney can speak with, can consult with, can hire even, and never disclose that expert to the prosecution unless they intend to call them. And this does happen. Sometimes defense attorneys will hire an expert, have an expert do an evaluation, realize that that evidence is not all that helpful to them, and say, well, I'm just not going to call this person. And they're not under an obligation to turn that over to the prosecution. It's only once they've decided, I'm going to use this witness at trial, do they then need to turn everything over. Now, at the point that they decide to turn everything over, that does include things like, did you pay them? How much did you pay them? What did you discuss with them? Did they provide you with any materials? All of that then becomes much more similar to this Rule 14 in Massachusetts. Why do I point all of this out? Well, one, I think it's important to understand that these are unique issues and they're uncommon issues. We're dealing with a situation, as was pointed out by defense attorney Alessi in the hearing. This is kind of uncharted waters, something we don't see all that often. Two, I point out that Alan Jackson practices in California and may not be as familiar with the Massachusetts rules. Now, he's practicing in Massachusetts now under what's called a pro hoc vice. He should be aware and understand, and his co-counsels and everyone should make him aware and understand all of the particulars of Massachusetts law. One other thing is that I have known Alan Jackson professionally and personally for a very long time. And I think he's one of the most trustworthy, straightforward attorneys I've ever met. So the idea that he would purposefully deceive the court is something I don't buy. However, what this is all about is what the judge seems most concerned with are representations that, one, all communications and discovery had been turned over when it looked like it had not. Okay? There was a sidebar hearing that took place earlier this month. So we're going back and we're talking about representations that were made before the first trial, representations that were made in hearings during the first trial, representations made after the first trial. But really, what the judge seems most concerned with is representations made earlier this month during a sidebar in which it was communicated to the judge by the defense that everything had been turned over. Now it's starting to look like that was not entirely true at the time that statement was made. The other reason this is important is that the relationship between the defense and ARCA may have been more involved than what both the court and frankly everyone else had been led to believe at the time. Now, it's part of the defense's job to disabuse the judge of that. And I think the defense did an admirable job of pointing out, listen, some of this is misunderstandings. Some of this is, it's true what the defense was saying at the time the defense was saying it. But if all of that seems to be problematic to the judge, and she likes to use that word, and then she gets a sidebar where it's told to her that everything that the defense has, the prosecution has, and then she finds out that's not entirely true, this is going to create some problems. So I'm going to reserve judgment on what the judge will actually do in this case. By the time this podcast comes out, the hearing will take place next week, and we won't actually have a decision on this. But here's some things that I think are going through the judge's head, and some options that the judge has on how to remedy this situation. I think, first of all, the judge is bothered and does feel like some remedy needs to be had here. First, she could preclude ARCA, those experts, from testifying, saying they also made misrepresentations. They also had communications that were not divulged, and therefore I'm precluding them from testifying. That would be a huge blow to the defense. This was an important witness for the defense. This was a centerpiece witness for the defense, and doing so could perhaps be cataclysmic to the defense. The other thing she could do is she could revoke Alan Jackson's pro hoc vice ability to practice in Massachusetts. He is not licensed in Massachusetts. He is operating essentially at the pleasure of the court, by permission. She could reject that. That, again, would be a huge blow to the defense. And it would perhaps have profound effects on Karen Reed's Sixth Amendment rights. The judge may feel differently because it's not like she's removing him as an attorney. She's just removing his ability to practice at the pleasure of the court in Massachusetts. I know I'm splitting some hairs here. That's another thing the judge could do. Both of those are incredibly drastic. I think where she will probably land, and again, I'm going to reserve judgment, but I think if you wanted me to make a bet on this, is that she could probably land on the idea of she's going to allow the ARCA experts to testify. She's going to allow Alan Jackson to remain on the case, but she's going to allow the Commonwealth to fully explore in front of the jury this evidence of perhaps prior relationships, payments made, emails exchanged, outlines handed over between the defense and these ARCA experts. And then the impact of these experts will probably not be the same that it was the first time around. The first time around, the defense made a great show of talking about how independent they were, how they never had any contact with them, how their reports were compiled without any influence by the defense. And that remains true. But now with all of these things that we have learned, it may be that the judge just allows the Commonwealth to get into all of that and cross-examine the experts on all of that, and perhaps prior inconsistent statements that they made in the first trial. And we'll see how the next jury views all of that. Again, I don't know. We'll find out next week. One last thing on this. What does it mean that the federal investigation in this case has ended? And that, according to reports, is what's happened, though that was not made clear in court earlier this week. Well, as far as for the trial, probably not much. Maybe as much as now, instead of hiding from the jurors the fact that the ARCA experts were hired by a quote unquote outside agency, now they will become aware that the feds actually did hire them, that the feds actually did conduct an investigation, and that the feds essentially did nothing and closed their investigation. How will the jurors view all of that? Who knows? They may view it as helpful to Karen Reed in the sense that they didn't find she was guilty of anything or decide that they're going to bring charges, but they also may view it the other way and say, well, listen, they also didn't stop the government from pursuing murder charges against her. I don't know. We'll see how it plays out. But from the court of public opinion, a lot of people put a lot of eggs into this basket that somehow this was going to have a fundamental impact on Karen Reed and her case and would clear her name. And obviously now that hasn't taken place. Last thing, there's a lot going on. We've got a trial approaching on April 1st. Do we think that's actually going to happen? Looks like it is. Looks like this judge is dead set on that taking place. So I say buckle up and stay tuned.
I don't know about you, but when I started saving as a child, I started with something as simple as a little piggy bank. Well, technology has kind of almost gotten rid of the piggy bank, as cute as it is. Today's episode is sponsored by Acorns Early. And I know you've heard me talk about Acorns Early before, but just in case you forgot, I'm going to remind you why it's such a great app. Acorns Early is a smart money app and a debit card for kids that helps them learn the value of money. Acorns Early Chores Tracker teaches kids that hard work pays off. Just set up chores in the app, then set a payment amount, and then tick the chore off when it's done. Acorns Early also lets parents pay allowances automatically, so there's no more searching for cash when it's time to pay up. Kids can spend what they earn with their very own debit card. They'll love the new sense of independence. Plus, parents can keep track of where and when the kids are spending. As parents, teaching our kids the value of money is so important, but it's not always easy to do. Acorns Early is an easy way to set your children up for success at an early age. Plus, it's a fun way to incentivize them to do their chores. Ready to help your kids learn the value of money? Just head to acornsearly.com/truecrime or download the Acorns Early app to get started. Sign up now and your first month is on us. T&Cs apply. Monthly subscription fee starting at $5 per month unless canceled.
Let's move on to Manitowoc, Wisconsin, where the trial for a man charged with abuse and murder and the death of a child will be delayed after the judge in the case rejected a mutually accepted plea. Timothy Hauschultz was slated to begin trial for the death of his great-nephew, Ethan Hauschultz, who was found dead in a snowbank. The 7-year-old was reportedly abused, beaten, and forced to carry a 44-pound log around the yard before he eventually died, buried under 80 pounds of snow. Hauschultz allegedly instructed his son Damien to administer the punishment which caused the child's death, and Damien was later convicted in Ethan's demise. Hauschultz faced 8 counts in the death, including felony murder and child abuse. However, prosecutors in Hauschultz's defense struck a deal which would have seen the man plead guilty to 2 counts of being party to child abuse, which would have carried a maximum sentence of 12 years. Judge Geraldine Dietz outright rejected the deal, reasoning that the proposed offer was not in the public's interest. Hauschultz's defense opposed and introduced a motion for Dietz to recuse herself, which was declined, before eventually filing a motion to stay the trial. The proceedings, which were scheduled to begin this week, are now going to be stayed, with the parties set to appear in court next week to discuss the future of the case. This is a remarkable kind of turn of events in court. Does a judge have the power to reject a plea? Absolutely. But how often does it happen? Very rarely. More often you see it on the federal level. On the federal level, though, things operate very differently than on the state level. On the federal level, there isn't even as much plea negotiation as we see on the state level. It's much more up to the judge in the first place, and most parties understand that going in. But on the state level, just with the volume of work that they have and just with the culture that's been cultivated, plea negotiations take place all the time, every single day. Most cases, the vast majority of cases, are dealt with during plea negotiations. And it's the prosecution dealing with the defense, working something out and getting that case handled before it goes to trial. If every single case went to trial, there is no way our system can handle it. So we rely upon plea negotiation. And we rely upon this free kind of negotiation taking place between the prosecution and the defense that it really is not interfered all that much by the judge. Judges will get involved if they feel like there is some sort of inappropriate message being sent. In other words, does it appear as though a very rich person is getting a better deal than some other person might get? You've got a rich person accused with, say, petty theft, shoplifting. Are they getting some sweetheart deal that every other person who comes in with shoplifting might not get? Something like that. Something that might reflect some sort of racial bias. These are things where a judge might get involved. But it's rare for a judge in a case of this importance and magnitude to say, I'm just not going to accept this. And why do judges not get involved? And why do we not see that all this often? Because judges simply do not know as much about the case as the attorneys. And there's a good reason for that. Judges, for the most part, are tasked with trying to be impartial in all of this. They know about as much as they need to know to make judgments on certain evidentiary issues. But they may not know and in most cases have never seen a lot of the evidence that's going into a case. During a preliminary hearing, they're going to hear some of it. There's going to be evidence put in front of the judge for the judge to make that very specific determination about probable cause. But as far as all of the witnesses, all of the problems with witnesses, all of the intricacies of the case, they're not privy to all of that. So usually, unless I said there's some sort of outlier reason, the prosecution and defense go in front of a judge and they say, here's the plea we've worked out, the judge will accept it. I have dealt with this before, and it's extremely frustrating. And many times the judge feels that they're doing this for some overarching broad reason about the interests of justice, but they're not actually getting to those ends by frustrating the work of the prosecution and the defense. That's an adversarial relationship between the prosecution and the defense. They are representing their respective sides, and they do expect to meet in the middle. So you would imagine that when they have a plea deal, even when that seems like something that the judge may not agree to, given the limited information the judge has, the judge usually trusts that those attorneys know what's best for their respective sides. Trials, the other thing to consider is that trials are not a given. Just because the judge doesn't like this, the judge feels like this is too lenient a plea deal for the defendant. Who knows if this case is going to prevail at trial? The judge does not know perhaps the problems that the prosecution knows. There might be a reason why the prosecution is giving a deal like this. And that might be something that the judge is not aware of and shouldn't be aware of. And certainly, trials are not a place where we just leave things to chance. Now, the other thing about all of this is, does it create appealable issues? I think so. There's a problem with the idea of a judge rejecting it without having a basis for it. The judge probably put a basis on the record. An appellate court will probably take a look at that if this goes to trial and if this person is convicted. A judge does enjoy that discretion. But I think that's the other reason why you saw the defense attorneys make a motion to recuse this judge, is that perhaps the attorneys felt that this judge had become embroiled personally in the case. And if that's true, and if there's evidence of that, that will certainly create an appealable issue. At the end of the day, I think this judge is causing more problems than she's actually trying to prevent. And I think that is unfortunate. But we will see how this whole case plays out. Finally, we move on to San Diego, California, where a woman who pled guilty to the killing of her husband years ago is now wanted for the murder of her wife as a federal manhunt is underway. Slain Fire Captain Rebecca Morodi was discovered with fatal stab wounds, and her wife, Yolanda Morodi, was nowhere to be found, with authorities believing Yolanda may have fled to Mexico after the killing. However, this is not the first time Yolanda has been accused of stabbing a partner. In 2004, Yolanda, who was then known as Yolanda Olejniczak, pled guilty to voluntary manslaughter in the fatal stabbing of her husband, James Olejniczak. Yolanda was released in 2013 and remained on parole until 2015. Police claim that Yolanda was not a reformed woman, and ring camera footage taken from the incident depicts Morodi running from Yolanda screaming, "Please, I don't want to die." According to the arrest, Yolanda chillingly responded, quote, "You should have thought about that before," while raising the knife that would allegedly end Morodi's life. First off, wow. There is a lot going on in this case, a lot to unwind, but the circumstances of the murder themselves are just nightmarish. I think the first thing to discuss, though, is there a failure of the system here? Should she have been locked up for life for that first killing? I think everybody, in light of what's happening now, might say to themselves, absolutely. But I think it's important to take a breath and take a step back and say, well, one, we don't know the circumstances of the prior killing. We don't know, again, we talked about this. We don't know for whatever reason she was given that plea deal that she accepted. She went to prison. She went to prison for 11 years. That's not a walk in the park. But it's certainly not life for taking somebody else's life. So why? We don't know why, but let's assume that it was done for the right reasons, if we can. Is it now somehow appropriate to look back on that and say they made a mistake because they didn't realize or didn't properly assess the risk that this person was back then? And again, I think what all of this does is really highlight how difficult doing the job of a prosecutor is. Doing the job of a prosecutor isn't just about getting the most possible time you can on every single case. It's about what we talked about earlier too, sometimes for the vast majority of cases, you have to come to some sort of negotiated plea deal. And sometimes that means showing some leniency, showing some mercy, trying to get a deal that the defense will also accept. Does that mean you should be giving away cases? Absolutely not. Does that mean you should be letting violent people plead to things that are completely inappropriate? Absolutely not. Prosecutor's job, first and foremost, is protect the public. But I think it might be a little rash to say that there was a failure in protecting the public just because this person happened to commit another incredibly violent crime. But I know that will become one of the driving stories behind this case is she got away with it once, and because we allowed her to get away with it once, now she did it again. I don't know. I would like to know the circumstances of that prior case. Perhaps it was. Perhaps it was absolutely a failure of the system and the prosecutors involved to not get a stronger sentence against her the first time around, and that's what led to this tragic death the second time around. But I think I personally am more disturbed by the circumstances of this case. This sounds about as cold-blooded a murder as you can imagine. Someone begging for their life and telling them they should have thought about that before as you stab them to death. Sounds like she's on the run. We hope that she is apprehended quickly. This is obviously one of those cases that we're going to be following closely because of all of the intrigue and fascination surrounding it. But in the meantime, that is our show for this week. We'd like to give a very special thanks to our viewers and listeners. We appreciate your continued support. I'm your host, Josh Ritter. You can find me on Instagram and Twitter at Joshua Ritter ESQ or at joshuaritter.com. And if you want to hear my thoughts and coverage on even more true crime cases, you can also check out my brand new YouTube channel, Courtroom Confidential. And you can, of course, find all of our Sidebar episodes wherever you get your podcasts, and we would love to hear from you. If you've got questions or comments you'd like us to address, please tweet us your questions with the hashtag TCN Sidebar. And thank you again for joining us at the True Crime News Sidebar.